Finance Fund and Trafigura Pte Limited.
Yes, Mr. Kitchener, good morning.
Good morning, my lord, my lady. So we were discussing yesterday the conceptual and legal problems that arise on the basis of my learned friend's argument that a recipient making inquiries as to whether or not it can keep the money breaks the chain of causation. And our submission, as you know, is that it plainly does not and cannot. Confirming, the recipient seeking to confirm that it can keep the money is the essence of good faith. It confirms, it doesn't negative the causal link, it confirms the causal link because it demonstrates that the recipient is seeking to establish, in order to rely upon, the validity of the receipt. And if one receives confirmation of validity and acts on that, one is obviously relying on the validity of the receipt and acting on the basis of and by reason of the receipt. And my lord, just to make a point that perhaps should be obvious, but in the light of the way the learned friend puts the case, bears some emphasis. The causative effect of the confirmation of validity cannot depend on whether, as a matter of underlying reality, unknown to the recipient, the confirmation turns out to have been forged. That's completely irrelevant as a matter of causation. Of course, my lord, confirmation for the purpose of good faith can come in any number of ways. As an example that we discussed yesterday was the receipt of legal advice. But in this case, we got our confirmation of our entitlement to retain the money, and that led to the conclusions that we've seen in the judgment below. I showed you paragraph 110. And 110 is going to be relevant not only to the case as a whole, but it's also relevant to the question of payment 5, in fact, payments 2 to 5, because I don't remember if I emphasised, but if not, I will now, that the last sentence of paragraph 110. Which talks about the later payments. And then paragraphs 112 and 113, and the particular words that I want to just remind you of in paragraphs 112 and 113 is the references to, well, in 112 is saying Trafigura had no knowledge of facts that gave them, or even should have given a reasonable person, reason to believe that the TPAs hadn't been signed, or that the payments were repayable. So that's a finding in relation to all the payments. And then you've got something similar in paragraph 113 about the continuing trading without knowledge or suspicion of anyone at Trafigura that the TPAs were valid, or the payments, i.e. all the payments, were repayable. And well, as I understand it, there's no challenge to those findings. We say that's necessarily dispositive. Well, it's worth coming back to the payments after payment 1. It's a point that my Lord Justice Nugee picked up on, and that led to my learned friend's confirmation after the short adjournment yesterday, that there was no claim in relation to payment, and really a very small residual claim in relation to payment 2. So payments 1 and 2 are irrecoverable on any basis. Now, my learned friend says, but of course, the history of payment 1 is important in looking at the later payments. And my lord, there he is absolutely right. Because the history of payment 1 and what happens obviously leads Trafigura to believe, as it does, and the judge says reasonably in good faith, that Rasmala is content with the general practice of payments being allocated to historic debts and through that being used to facilitate further deliveries. So, I mean, my lord, it's just really important given how they put their case under ground 2, which is the causation test. So their case, the Bull case, is that Trafigura knew at one point, or thought at one point, that payment 1 had to be allocated to future payments. We say that ignores the fact that before we change our position in reliance on that payment, we think we've got confirmation that we can allocate in the way that we do. And as the judge explains at paragraph 101 of the judgment, in fact, it just makes no difference to anyone anyway. I'm not going to belabor the points that we've made in relation to that, but their case essentially is that as a matter of the law of restitution, we're worse off than if the money had been stolen. But in any event, that argument only works for payment 1, because for the subsequent payments, the judge finds, and again, there's no appeal against this, he finds at paragraph 43, in the last paragraph, that after payment 1, there was no realisation that Rasmala was making its payments in respect of a specific contract to be performed in the future. Of course, the only reason that we thought there was that there was any question of allocation to a future contract was on the basis of what Falk told us anyway. That comes back to the point that I made at the start of my submissions yesterday about the appellant picking and choosing the bits of what Falk told us that they think are relevant to the legal structure of the claim. As I say, the allocation point on which my learned friend spent really a lot of his time yesterday only relates to payment 1 for which there is no claim. My lord, another way of putting that is in this way. After TPA 1, did we think or suspect that payment 2 was made by mistake? At any time. And if so, on what basis? We simply don't understand any basis on which it's even open to the appellant in terms of what's in its appellant's notice. The bits of the judgment that are challenged and not challenged, we don't think it's open to them to make that argument. But in any event, that argument would be hopeless. The judge, as we've seen, found to the contrary. I've shown you that in paragraphs 43 and in paragraph 110, where he says the subsequent facts could help confirm the position. So, my lord, coming on in slightly more detail to the law, you have the fundamental proposition of the change of position defence that the judge quotes. I won't take you to it again at paragraph 93 of the judgment, but you'll be very familiar with it. The question is whether the defendant's position has so changed that it would be inequitable in all the circumstances to require him to make restitution. So we start off with the nature of the claim, and the claim here is a claim in mistake. And the general principle we accept is that if a person makes a payment by mistake, they're entitled to recover that payment, subject to any applicable defences. Obviously, in order to make the claim, you're starting off with the claimant's mistake. That is the founding fact that kicks off the legal analysis. And as the judge records at paragraph 88 of the judgment, the claimant is entitled to recover regardless of how careless it may have been in making the mistake, and regardless of the fact that the claimant, in making the mistake, has done all of the things that it criticises the defendant for. I mean, that has particular resonance in this case, relying on forgeries, trusting Falk, and so on. And you may also have picked up on the judge below's reference, it's just in paragraph 100, to the rejection of, in English law, of the concept of relative fault in this area of law. So one doesn't weigh up the relative fault of both parties. Now, both of those propositions and their consequences we find in the judgment of the Privy Council in Dextra, in the authorities bundle at tab 8, at page 261. So, my lord, this is the judgment, a joint judgment of Lords Bingham and Goff. And 261, if you could please just read for yourselves paragraph 45 down to the letter E.
Yes?
So, my lord, that in particular, that explains why, for the purpose of the change of position defence, good faith rather than negligence is the test. It explains why there's no question of relative fault. It also might help explain the liberal nature of the causal connection that is required between the receipt and the detriment, including the level of proof required. That may explain why the courts have emphasised that the test is but for causation, and it's why this court made clear in Commerzbank, and I'm just quoting. I'll show you the passage in a moment. The need for a sufficient causal connection should not be narrowly applied. My lord, it's understandable why that should be the case, given that really what a party is seeking to do in a case like this is to have someone else bear the consequences of his or her own mistake. Sometimes in life one can have someone else pay for one's mistakes, but frequently one can't. So so that leads to the question then of what does good faith mean and what does it require? I think my learned friend was inclined to submit that good faith might have morphed into something that the phrase itself might not indicate, but in my respectful submission, nothing of the kind has happened. The phrase itself is to be contrasted with negligence, as you've seen in Dextra, and the phrase indicates that the concept is concerned with conscious conduct or conscious misconduct. My lord, I'm going to take you, I think I can do this briefly because my learned friend took you to some of the relevant passages in Nehru Battery, which is in the authorities tab 7. Now, this was a decision after Dextra, and you won't be surprised to hear that Mr. Justice Morbick, as the Court of Appeal did afterwards, accepted Dextra as representing English law. I don't think that I need to tell you very much about the facts, but it was a case in which the bank, Crédit Agricole, had sold goods. It had a warrant over goods as security for a transaction. It sold the goods pursuant to that warrant, and then received payment from another bank, Bank SEPA, under a letter of credit in relation to those same goods, but knowing that the goods had already been sold to someone else. So it knew that the payment under the letter of credit was made by mistake, Nevertheless, the bank allowed payment to be distributed pursuant to its customer's instructions, and that was on the basis of the customer telling the bank, well, I'm in negotiations with the seller for an alternative to transaction. Those negotiations are at a very sensitive time, and if you pay the money back, those negotiations might be kiboshed. It's not entirely surprising in those circumstances that that the bank is and the bank acts on those instructions. Not really surprising in those circumstances that that there's a finding of lack of good faith. The issue in that case, as I think my learned friend explained, was can you act in bad faith even if you haven't acted dishonestly? Got to be a little bit careful because the test for dishonesty, when Nehru Battery was decided in 2002, was a bit different to the test for dishonesty now. And there were greater elements of subjectivity than objectivity, but I'm not sure that matters too much for present purposes. But in that case, you'll see if you go to page 238, paragraph 120, just if you could just read the lines on that page, please.
Yes.
And then over the page at paragraph 121, just the first two lines, the first four lines.
Of which paragraph?
Of paragraph 121 on the following page.
Yes.
Then at paragraph 122, you see that the real question is whether bad faith means dishonesty.
Yes.
We can go over the page to page 240, and if you can look at paragraph 125, which is accepting what the Privy Council said in Dextra. And then you go to 135, which is a paragraph that's adopted by the Court of Appeal. It's expressly quoted by Lord Justice Clark.
We looked at this yesterday in the Court of Appeal judgment.
You did.
Yes.
You looked at this in the court.
Do you want us to look at any
Well,
part of it
I don't want to take too much time. I'll just point out what I think is important, if that's satisfactory. So the first thing he finds is that dishonesty isn't required in the twin sector sense. Dishonesty in the twin sector sense isn't really the current test, but I don't think you need to worry.
The current test?
Sorry,
what is the current test?
So the current test is that you have to know facts and behave in a way that is dishonest by the standards of ordinary men. But
how does that differ from the twin sector?
So from recollection, the test in twin sector is that you've got to know that you're behaving in a way that's dishonest. So you've got to subjectively know.
It's a broader definition now?
Yes, absolutely. It's broader now. And it's,
so what is the impact then on this sentence?
Well, it's just that you need where there's the distinction between dishonesty and bad faith might not be so significant now, given what the current test is for dishonesty.
Ivy and Genting, is it?
It's no, I think it's later. It's the Crown against.
No, it's Ivy.
Sorry.
It is
Ivy. It is Ivy and Gent. My lord's absolutely right. And
it's the lady and your junior.
I'm not sure actually that I may be misrecalling. I think twin sector is closer to the Ivy test, and there was another case of possibly that.
Well, but I don't. Sorry.
There's Barlow Clouds before.
Oh, Barlow Clouds before. I just thought it was worth mentioning that the dishonesty test.
How does that affect our interpretation of the sentence that you draw to our attention?
My lord, I don't think it does. I just wanted to draw your attention to the fact that the dishonesty test is something that has moved over the years. But the key for my purpose is that first of all, the judge says, I don't think it's desirable to attempt to define the limits of good faith. It's a broad concept. It's capable of embracing a failure to act in a commercially acceptable way in sharp practice, short of outright dishonesty, as well as dishonesty itself. The factors that determine will vary from case to case, but it will depend on the circumstances in which it is. So the extent to which, the extent of his knowledge about how the payment came to be made, obviously where you know the payment has been made by mistake, then the position's clear. Then a little bit further down, greater difficulty may arise in cases where the payee has grounds for believing. And then you've got to make inquiries. That you'll understand now why I say
May
that.
well dictate.
Yeah, absolutely. So that's important for my purposes, or for everyone's purposes, because that's what we do. This is also important. The nature and extent of the inquiry will depend on the circumstances of the inquiry called for. Will depend on the circumstances of the case. But if you have or think you have good reason to believe the payment was made by mistake, then really you've got to make inquiries. Or ordinarily you'll have to make inquiries. And then over the page, at 138, and again, this is another passage that was quoted with approval by Lord Justice Clark.
Can I just go back to that last sentence?
Yeah.
131. What he's saying is he doesn't think that a person who has good reason to believe it was made by mistake will often be found to have acted in faith if he pays the money away without first making inquiries.
Yeah, exactly. Of course, we made the payment after making inquiries, and my learned friend is relying on the inquiries as essentially negativing our ability to change our position.
Whereas your point is, it's the making of inquiries, the fact that you made the inquiries shores up your claim that you acted in good faith.
That's what we've been told. That's what the law tells us we've got to do. Exactly.
He said you should have made inquiries of Rasmala directly.
Well, my lord, that's what my learned friend suggests. But from our perspective, we have made inquiries of the payer. We've done it through the medium of communication that the payer itself put in place. And the judge held that we acted reasonably. You may be unsurprised by that finding, given the evidence that I've shown you from Mr. Bitcon. But we thought we were making inquiries of the person from whom we received it. And we thought we were getting confirmation from them. And that's what the judge finds in paragraph 110. But of course, in this case, making inquiries of the person from whom you've received it makes perfect sense, because what's happened in this case, in Nairu Battery, is that the bank knows of the mistake, but the bank's customer says, "Oh well, don't pay the money back because that'll make life difficult for us in our negotiations." And Mr. Justice Moore-Bick is saying, well, it's not enough to speak to your own customer about that. You've got to speak to the payer about it. So it's not surprising that he uses that formulation in that case. But more importantly, what he says is that the nature of the inquiries depends on the circumstances of the case. Now, in that case, what you need to do is you need to ask the person who's making the payment. I mean, just to give another example, is that you might need to take legal advice. Let's take another example from your Miller case. So the facts of Miller, let me see if I can, Weber. So let me see if I can just remember to roughly what the facts of that case were. So it was a case where you've got a teacher who's entitled to a pension, and is told by the pension provider that they've got to keep the pension provider updated with knowledge of ongoing earnings, and he doesn't do that, and he takes the risk in those circumstances that he's being overpaid, and he turns a blind eye. This is actually a finding of the Ombudsman, but it's a finding that you uphold. He turns a blind eye.
An appeal on a point of law from
It is. That's
from the Ombudsman.
That's-
You didn't uphold it.
So it's not a question of upholding a finding. You have the findings
Yes.
of fact by the Ombudsman,
yes, and
and the question is, was there any error of law?
so there were actually. I mean, maybe I should wait and actually go to the
Have we got it in the bundle?
Yes, of course we did. Yeah.
Okay. Well, do you want to look at it?
Yeah.
Both of you trying to do it from memory.
I'm sorry.
Both of you trying to do it from memory.
Yeah,
I've never read
that
it.
that may be preferable. But then say just 138.
Right. Okay. Staying with.
Just staying in Nauru.
Right, yeah.
I mean, the reason that you need to make inquiries is because otherwise you're acting in the knowledge that you may be infringing the rights of another.
We haven't looked at this paragraph. Let's
Yeah.
just read this.
So that's sort of it's in the middle. And then the last sentence as well. So he's not consciously acting in disregard of the standards to be expected, but he was willing to accept the risk that he might be infringing bank sector's rights.
Is good faith for the defendant to prove in a change of position defence? I mean, I very
Yes.
much doubt anything turns on the burden of proof.
Yes.
Yes.
Essentially, though, your point at all this is this. It runs into the findings of fact made by the judge.
Absolutely. Absolutely.
I mean, it could be in these situations. It all turns on the facts, and here we've got
it does.
findings which
It
the
does.
judge,
And-
which can't be challenged in the school.
And the reason, well, my lord, I respectfully agree with that, but I thought it was worth showing you, Mr. Justice Morbeck, first of all, saying that in terms that the inquiries you need to make are fact sensitive,
Yeah.
which reinforces the points that you've made, and there are no and cannot be. If you're looking at what's commercially acceptable and what's sharp practice, I mean that tells you that there cannot be any a priori rules as to the nature of the inquiries that you need to make. You need to make. It's all going to depend. I think this is the point my lady made. It's going to be fact sensitive. It's going to depend, and it doesn't depend just on commercial good sense, as my learned friend suggested. It depends on the evidence, and the evidence in this case almost mandated the answer that what Trafigura had done in making its inquiries was commercially acceptable.
Doesn't
Commercially
matter.
acceptable
I mean,
practice.
that's in your case. That submission doesn't matter, does it? The
No.
judge made a finding. That's it.
Yeah, absolutely. And there is no basis to interfere with that.
No.
But you also see, as I say, the other reason I wanted to emphasise, Nara, is because, as I say, it emphasises this stage of making inquiries, and those inquiries can't break the chain of causation. You just make a nonsense of the structure of how the law works in this area. And then I'm bound to come to Weber now, my lord.
Well,
It's,
my lord hasn't read it. He's
I
deprived
read it.
himself.
I didn't read. I read Mr. Justice Mumby last night. I didn't read my lord.
my lord,
My fault.
the selection of reading it's a question of choices.
But you can see why I read Mr. Justice Mumby.
Again, and to be fair, it's a good read. Not that I'm suggesting that my Lord Justice Nugee's judgment is not.
Well, I hadn't thought you were until you made that suggestion. Where do we find Weber?
So it's at tab 20.
Okay.
So Mr. Webber's a teacher. He takes early retirement and starts receiving his pension. He begins teaching again, and the pension scheme tells him he needs to keep the scheme updated with his earnings, as it might affect his pension, but he doesn't do that. The scheme then realises they've been overpaying and sought to recover about £36,000 from him, and Mr. Webber made a number of objections, and he claims to the pensions ombudsman, and it comes up to the Chancery Division on 2 separate occasions.
With Mr. Webber in person.
I think that's right. And he's if he was in person on the first
He's in person here, this judgment.
yeah. So he succeeds in the first instance, and then doesn't succeed. So in front of Mrs. Justice Appellant. I mean, he scores a slightly Pyrrhic victory because he gets the judgment overturned on the basis that the reasons aren't good enough, and then you may be surprised to hear the Ombudsman improves his reasons, and then Mr. Justice Nugee, as he then was, says, well, what can you do?
Right.
So if we look at, if we go to page 677, paragraph 31, so it's actually the Deputy Pensions Ombudsman, the DPO. So he finds that Mr. Webber ought reasonably to have been aware that he needed to take action each year. And Mrs. Justice Asplin upholds Mr. Webber's appeal. We can see the basis on which she does that at paragraph 32, in particular at sub 3. So the the complaint is that there's been the application of an objective test, and that was the wrong test. So the matter's remitted back to the DPO, who says that Mr. Webber was actually aware there was a possibility he'd been overpaid but turned a blind eye, and we see that at paragraph 40 at page 680. In particular, the last sentence of the quotation, finding D, just the sentence starting, however I'm persuaded. And then if we go from there, please, to page 684, paragraph 57. And then paragraph 58, I think you only need to look at the first, at the part of paragraph 58 on this page. Happy for you to look at the rest if you would like. And then 686, page 686 at paragraph 62.
Where my Lord has quotes the passages in Mr. Justice Morbeck's judgments.
Yeah.
135 and 138.
Back to 135.
You've taken us to.
Yes, exactly. They're the key paragraphs.
And then 62.
Yeah. So he's knowingly taking a risk and again, it's absolutely fair to say that my lord in this case says that you should speak to, you can make a simple inquiry of the payer. In that case, obviously, that's the simple and straightforward thing to do. But again, one can imagine there might be other inquiries one could make. Suppose one consulted an actuary, and the actuary or a lawyer, and the actuary or the lawyer said, no, you're perfectly entitled to this pension. It's exactly what you're entitled to, and you change your position on that basis. So, my lord, when my lord was discussing with my learned friend the question of the case of Rose, AIB and Rose, and I think my lord made the point that the facts of Rose are different, and I think my lord and my learned friend accepted that there are no facts. There are no cases on facts similar to ours, where inquiries have made that confirm or appear to confirm the validity of the payment. My lord, the reason there are no cases similar to ours is for the very simple reason that you just wouldn't expect there to be a case in which someone who's made a payment under a mistake has disputed the ability of a recipient to rely on a change of position made in good faith following what the judge below finds to be inquiries made reasonably in good faith. And the essence of this case when it started and up to trial was that Trafigura knew or suspected that the TPAs were forged. But it's only once it became obvious that that case couldn't be sustained that the case morphed into a very different case, and we would suggest an impossible case, that we weren't entitled to rely on the TPAs at all. But once, in my submission, once the question of suspicion of the TPAs being forged goes by the wayside, then the result is essentially mandated as the result that the judge below reached. I'll just quickly deal with Rose, just to draw out what we say are the key aspects of it. It's at tab 9 of the authorities bundle, at page 263. And in that case, the bank knew there was at least a significant risk that the liquidator had a good restitutionary claim to recover the money. That's the key. We get that from paragraph 55 at page 279. And the facts of the case, I think you've probably picked up, but after a winding up petition is presented, the company pays off its debts to the bank. Those payments are void under section 127 of the Insolvency Act. The bank learns of the winding up petition. The company goes into liquidation. The bank knows of the liquidation. The bank just forms a view that the liquidator isn't going to pursue his legal claims. And on that basis releases a charge securing the debts that it is owed or would be owed if a restitutionary claim is made and succeeds. But at the time that it releases the charge, it knows all the relevant facts. It knows the only assumption that it makes is that the legal claims that the liquidator has will not be pursued. So we start on paragraph 49 at page 278. And the key holding of Mr. Warren QC sitting as a deputy is in paragraph 49, 5 lines down.
Yes.
The bank needs to show that it changed its position on the faith of the validity of the receipt. And as with all of these cases, as we've seen in Weber, as we've seen in Nehru, again, all of the change of good faith and the test is always applied as at the date of that the position changes, and that's why good faith has to be looked at in the context of the inquiries that one has made between the date of the receipt and the date of payment. But this is so you've got to make a payment on the faith not just of the receipt but on the validity of the receipt. Obviously, if you know that the receipt is invalid, and you know that at the time that you change your position, then the defence isn't going to work. And my lord, that formulation is followed in 55. Where the judge says, just below the letter C, I don't think the bank can be said to be relying on the validity of the credits. Then letter D, the change of position was not made in reliance upon the initial validity of the credits. And then 56, the judge makes what you would have thought is a fairly obvious point. It's just a question of whether or not one's assumptions as to whether or not legal claims are going to be pursued. And then paragraph 58 might be important to a degree. So my learned friend said that this case is inconsistent with the but-for test. But actually what 58 says is, if contrary to the views which I've expressed, it goes too far to say the bank did not in changing position rely at all on the validity of the credits, then we're going to go on to consider the question of allocation of risk. So that actually indicates that the judge thought the but-for test was the correct test. The use of the words at all indicate he was quite happy to say that the relevant causation test is met if you're relying on the validity of the credit and a number of other things. So that actually, maybe it's just a straw in the wind, but it's important in my respectful submission in relation to.
Well, a but-for test isn't a complete answer in this sense that clearly, if the payments hadn't been paid, there couldn't have been a change of position.
Yeah.
So that's, it really depends what you mean by a but-for test. And
Well,
I'm
absolutely.
not sure you've got onto that because we're on good faith, but.
I mean, obviously, there's a sense in which one is always acting. In which the payment is always going to be a cause in that sense. But if you think that the payment's invalid, then the change of position defence isn't going to work, and that's not a causation point at all. You're not acting in good faith on the basis that this is money that you're allowed to use for the purpose for which you use it. You just don't get to the change of position defence. You know, the essential substratum is missing. It's nothing to do with causation.
So you say Rose is really a good faith example.
Yeah, that's how it's best. That's how it's best understood.
In the same way as Neo.
That's how it's best understood. That's how it's best understood.
Well, I'm not sure that's quite how the judge reasons it. The judge reasons it as you can only claim a change of position if you're relying on the validity of the payment. That's the way he puts it.
Yeah.
And he says the bank wasn't relying on the validity
Yeah.
because it knew there was a
Yeah.
doubt over the validity of the payment.
Well, I mean, my lord. I mean, it may not matter precisely which
No.
formulation one applies, but
But that concept of relying on the validity of the payment is a theme one sees through the cases. But
Yeah.
if you understand it this way, that you're relying on the validity of the payment. If you don't have any reason to think, and you don't think, there's a query over it.
Exactly.
And in your case, you might have had a query over payment 1, but you say, well, we resolved that with TPA 1, and thereafter we didn't have it. Well, the judge found that we didn't have
The
any
judge found that we didn't have
any
anything.
reason to doubt the validity of the payments. And in
And
that
didn't.
sense, you obviously are relying on the validity of the payments.
Yeah, exactly.
And I think that could be put, if you have to put it into a box, could be put in the box marked causation as well as in the box marked good faith. I mean, what causes you to act as you did is your
Yeah.
belief which happens to be a good faith belief, but you believe the payments were valid and it was up to you how you treated them.
Yeah.
And it's because you had that belief, which the judge says was entirely reasonable,
Yeah.
that you did what you rely on as the change of position, which is you carry on trading and enter into another 60 contracts with
It's just
Berlin. So I'm not sure you have to pigeonhole
No.
Rose
Well-
into either good faith
No,
or
I think-
causation. I think the two do go together.
I mean, it's just the wrong kind of belief, isn't it? That the bank has. The bank just doesn't have the kind of belief that entitles it, or that it thinks entitle it, to use the money for the purpose that it uses it, or to change the position.
They have a belief that it's safe to discharge the charge because the belief is the liquidator's not going to do anything about it. Not that the
Exactly.
liquidator doesn't have a claim.
My lord's absolutely right. The belief is that it's safe,
Yeah.
not that they've got a legal right to do it. And that just doesn't get. I mean, it might be slightly problematic that we're generally used to looking at causation in terms of the cause of loss resulting in a breach of duty, and it might be that concept doesn't map itself perfectly onto the change of position defence, and that might be an explanation, at least in part, as to why in Commerzbank this court explains that really you can't be too prescriptive in relation to looking at what the relationship is between the payment and the change of position, or the detriment that constitutes the change of position. But whichever lens you want to look at the case through, Rose, as I said yesterday, it's not just distinguishable, it's a completely different set of facts. It's almost, I mean, in some respects, it's the opposite of our case. Because again, in Rose, and you see it over the page at page 280, at paragraph 58, this is the judge's alternative analysis. This is the taking the risk analysis. And the judge says below B, I suppose one could say that the bank wished to let that sleeping dog continue its lengthy slumber. But that, again, that's just the opposite of what we did. And that's why there aren't any cases, I would respectfully suggest, on facts similar to ours, because we've done exactly what the cases say that you should do, and the judge, having made the findings that he has, that there's no proper basis to interfere with, and it's just dispositive of the question. So then just looking at some of the authorities, some of the learning on causation. So the key question is, we suggest, is the chain of causation broken by the inquiries that we make? I mean, if so, is it broken by any kind of inquiries? Is it broken by any information other than the fact of the payment from any source? I mean, once one starts asking these questions, one sees how difficult it is to apply or even formulate the test that my own friend invites this court to adopt. But our key propositions that the authorities make it clear that the test is but for. There's no incorporation of the common law rules applicable to claims for damages in tort, such as effective cause or operative cause. There needn't be any communication from the payer, or indeed anyone at all. All you need is a detriment that would not have happened but for the payment. And finally, in our case, we say that there just isn't any conceivable test of causation that we would not satisfy. Well, can I start with a couple of the academics? Lord Burroughs, Andrew Burroughs, Time, tab 26, at page 828. And it's fair to say that one of the reasons I'm showing you this is it's fair to say that there have been historically some suggestions that certain kinds of detriment, certain kinds of losses might be too far removed from the enrichment to qualify as changes of position. Now, look, that's a very different question to the question that we're looking at now. We're not looking at whether the nature of the loss is too far removed causally. We're looking at the question of whether the inquiries that one makes as to whether or not one can keep the payment break the chain of causation. But in any event, if we look at what the author says under the heading D, causation at 828, well, perhaps if I could ask you just to read down to the end of the second paragraph, ending in the enrichment received, within the middle of the page. Okay. Where are we? Page 828, tab 26. So again, it's a slightly different question that the author is asking, but in any event, he's saying that the argument has been rejected in Commerzbank. So and hopefully you'll have seen the if you read the passage there, then I won't have to take you to the case because this is the key. This is the key paragraph.
Yep.
There should just be a relevant connection. And we say the test of relevant connection is obviously satisfied in our case.
How would you distinguish in a simple sentence or phrase the difference between causation and relevant connection?
Well, it's essentially a but-for test. We say it is a but-for test, and that's how I think that's how the author sees it. On the fact that in Commerzbank there was just no connection at all. There was no causal connection at all.
I mean, the comment that Professor Burrows makes after citing that passage,
Yeah.
at first blush, seems to suggest there's a distinction between relevant connection and but for.
Well,
He held there was no relevant connection. That was straightforward. I'm emphasising that word.
Yeah.
Because but for connection, because he was not satisfied.
Yeah.
Well, maybe I'm misreading too much.
My lord, I mean, I would respectfully suggest that may be the case.
Well, there's, to ask the question a different way, there isn't an explicit endorsement of the but-for test in the authorities.
In this?
In any of the authorities.
Well, other than what we've got is the Scottish equitable case that my learned friend showed you yesterday, which said what you've got to show is causation on at least but for.
Yes.
That's paragraph 30 of Scottish equitable.
Yes.
But
no explicit endorsement of that being sufficient.
Where?
That's as I understand it, there is nothing other than that.
No, I mean, I think there are lots of other cases where the Scottish equitable test is referred to and as being the law. There's certainly no case that says.
Well, put it this way. Well, Justice Mummery refers to sufficient causal link.
Yeah.
He doesn't use the words but for.
No, he doesn't. But I mean, in that case, he really doesn't have to. In that case, he's saying that the finding was there was just no connection. There was no connection at all. But what he says is, and Andrew Burrows, in my respectful submission, correctly identifies that there's a rejection of, well, the common law test, the tort test, and questions of remoteness, because he's saying you just shouldn't narrowly apply the need for a sufficient causal link. So if you apply the causal link broadly, essentially you've got the but-for test. You're saying what you shouldn't do is narrow down the but-for test by reference to the principles with which we're familiar in the law of tort. So, for example, and it's readily understandable why that might be the case. I mean, suppose, for example, you're looking at the test of foreseeability in tort.
Well, we're not, are we?
No, exactly. Well, we're not.
We were told to ignore the learning
Exactly.
of causation.
Exactly.
But I'm focusing on whether your assertion that relevant connection equals but for is right, and A is right, and B is what Professor Burrows is saying,
Well,
or indeed what
More
Mummery was-
importantly,
what
what
Lord
you're
Justice
saying.
Mummery was saying. I mean, more importantly, at the time. Let's not go there, please. But I put it to you that it's not the same. Reading those passages, reading what Lord Justice Mummery was saying, and what Professor Burrows interpreted was saying, suggests that they are not the same thing. And now I'm trying to work out exactly how they're different.
Well, exactly. What could be the difference between a but-for cause and a relevant cause? I mean, it's simply...
It doesn't say cause. The word cause is relevant connection.
But as I say, but there, the need for a sufficient causal link is not to be narrowly applied. There needs to be a relevant connection.
Is a relevant connection a broader concept than but for? But for does actually implies a causal link.
Yeah.
Relevant connection doesn't necessarily apply a causal link, does it?
Well, on that basis, he can't be saying that there needn't be any causal link at all. I mean, the only way of making sense of it, in my respectful submission, he's saying, obviously, you need a causal link.
Well,
It's
yeah,
not to be
right. He
narrowly...
says that the need for a sufficient causal link should not be narrowly applied.
Exactly. Not narrowly applied. Well, but that's exactly what my learned friend's inviting you to do.
Yes, but you have a specific response to that in terms of it can't be the case that the inquiries you make as part of, if you like, a good faith exercise can't put you in a worse position.
Yeah.
That is something you could say could fit within the framework of this without reading what Lord Justice Mummery said as a but-for test.
My lady, I accept that. I accept that.
That might also, I know we've discussed Rose already, but as also discussed there, in one sense, a but-for test, Rose might be said to illustrate the but-for test.
I mean, there are potentially at least two separate questions, and it might be important to distinguish between those two. So the first question is, what causation or what connection do you need between the payment and the act that leads to the detriment? And in my respectful submission, that has to be just a but-for test.
Sorry, by the detriment, you mean the change of...
Can be, but isn't always. And for example, we know from the theft example, I mean, the theft example only makes sense on the basis of but-for causation. It's not, you wouldn't say it's foreseeable. You wouldn't say that the payment is the operative cause of the theft. It only makes sense on the basis of but-for causation. The intervention of a third party. But
how would you? So we're using this label "but for." expand that out to what is a shorthand. What does it actually mean?
Well, it just means that had the payment not been made, the act that has led to the detriment wouldn't have occurred.
Had the payment not been made?
But what it doesn't do, what it doesn't do is exclude the possibility of other causes. So the key, my learned, that's why it's important that to understand that what my learned friend is trying to do is to say that because there are causes in addition to the payment, those additional causes mean that you ignore what is obviously a but-for cause, i.e. the fact of the payment. But whatever inquiries you make in order to form the view that you're entitled to use the money in the way that you do use it that constitutes a detriment, that cannot interfere with the chain of causation the way that my learned friend suggests, for the reasons that I've given.
When one looks at the page of boroughs which we were looking at, it's apparent this is just one section in a longer section on change of position. And at the top of the page, it looks as if there's been a discussion as to whether you take the wider version or the narrower version.
Yeah.
If you look at the bottom of the page, you can see that he's going to go on to have a discussion about what the rationale is, whether it's disenrichment, that beautiful word, or the true rationale is to protect security of receipt.
Yeah.
And I just wonder if those passages might be
We can have a look.
of interest, just to set this, which by itself is quite a short bit in Professor Andrew Burroughs' longer discussion of the whole.
Well, we can certainly have a look. I mean, the one thing we do know is that Professor Burroughs was a proponent of the wide view rather than the narrow.
Yes, you can see that from the top. But anyway,
Well, maybe we should.
it might be interesting just to see
Maybe we should have a look. Maybe we'll have a look at that, and if there's anything that we think is important, we'll draw it to your attention. But as I say, the wide view is very strongly indicative of a but-for test.
the wide view is the view that you don't need reliance because that doesn't cater for a theft example.
Yeah.
And that's certainly what Lord Justice Robert Walker says in Scottish Exeter and Derby. Is there actually a decision to that effect, or is it just
In terms of the wide view, I mean, so in Scottish, there is. It's the decision of the Privy Council in Delta.
Yeah.
Right.
Sorry?
I don't want to interrupt.
Right.
Shall I-
That's Professor Burroughs. We're going to Professor Virgo and Professor Gareth
Well,
Jones.
let's just have a. I was just going to take you to Professor Virgo. It's behind tab 28. It's page 841. So you see the first sentence.
Sorry, for some reason I'm missing.
Do you not have the page? Do you have the hard
Give me
copy?
the internal,
The last document.
Yeah.
internal page of the book.
757.
Internal 757. Yeah, I have the same problem, my lady, because the numbers are blacked out. So
There it is in the first sentence. In his,
Yeah, so there must be a causal link between the receipt and the change of position, so that but for the receipt, the defence position wouldn't have changed. And that you see the reference there to Delta Petroleum, which is the Privy Council case that I'm going to take you to in a moment. The leading case on the interpretation is Scottish Equitable. And then you can read down to the end of the paragraph in the middle of the page. So there's an indication of, well, clearly you get the author here thinks that but for is the relevant test. And again, he links that, as I suggest, is appropriate to the adoption of the wide test.
So this Professor Verger's articulation it seems to fit firmly
Yeah.
with yours.
Yeah. Yeah.
Just to save time, she might ask him to read the last paragraph on the page.
Yeah, the Berlin friend wants you to read the last paragraph on the page of 757.
Let's do that.
Thank you.
Again, I'm not quite sure why my learned friend is so keen on this paragraph. I mean, there are two ways of showing causation. The second is reliance on the validity of the receipt of the benefit. The first is just no longer retaining it. I mean, in our case, we've sort of got a combination of the two. We could succeed on the basis of either test. And of course, the first test requires nothing more than but for.
Why do you say you no longer retain it? Was there any evidence of what you did with the money? I mean, to say you used it, you set it against their debts, doesn't mean you don't have the money.
Well, we've used it to deliver coal.
No, you applied it against the debts. The cash
Yeah.
might still be in your account for all the judge knows.
Well,
Isn't this really a case of reliance?
well, yes, but as a matter of commercial reality, it doesn't really make any difference, does it? Because what we've done is that we've converted the cash into coal that we've sent to Falk.
Does the judge have any evidence of that, or did he
Yeah.
make findings as to that? I mean, I can see
Yes, he does.
why you say that as a matter of commercial reality is what
Yeah.
happened, but that's not the basis on which it doesn't say you can't give the money back because you no longer have it. Does he?
No, what he says is he explains the position at paragraphs 105 and 106.
Because in the case of a theft case, it's very easy to see that if the very money that you've received is stolen from you, you can't be expected to give it back because you just don't have it.
Yeah.
I mean, Trafigura is a very large organisation. This money would have just gone into its judging resources. The key point is the one you made, that receipts were relied on to allow further trading.
Yeah.
That's the critical point.
Yeah, absolutely. But as I say, I do, in my respectful submission, it's fair to make the point that the cash was essentially.
That's not how business
You
works.
don't-
The cash wasn't used in that way. There's no evidence.
Well, that's just because we gave them credit. I mean, if they didn't have a credit, if they didn't have a rolling credit, that's exactly how it would have worked.
But do you need this last paragraph from? Do
No,
you
I-
need?
No,
which
I
seems
don't.
to-
But I'm just, I'm just using.
He needs it.
That was my idea, I'm afraid.
I'm
Yes.
just.
Yes,
It's
I
just-
mean, the first sentence covers the round the world cruise and
Yeah.
the theft, doesn't it? Really?
Or the theft.
Certainly covers the theft.
Yeah, but we're in, as I say, there is an analogy to our case of the theft example, because essentially what's happened is, well, I mean, Rasmala was defrauded out of its money, but we were defrauded as well into allowing the money to be used to deliver coal worth $22 million. So in my respectful submission, it is very hard to understand any.
Why do you say to be used to deliver coal worth $22 million? I mean, we don't actually. Do we know how much coal you bought?
All of it. Well, we know that the balance on. I mean, that's the basis of the change of position defence. We know that the balance on the
went up from 10 to 12.
It went up
to 14 to
Yeah.
15. And therefore, you say, well, since we have taken this money and set it against historic debts, it's implicit in that we have delivered that much coal to them because their your total exposure to them has gone up.
Exactly. So we say there's really a very close analogy between the theft example and the money coming into our account and our being persuaded to allow the further deliveries of coal to be made on the basis of what turn out to be forged TPAs. My respectful submission is a commercial matter. There's just no relevant difference. We've been defrauded out of $22 million worth of coal on the basis of these forged TPAs.
Well, you haven't been defrauded of $22 million worth of coal.
Well, we were. Well, it'll turn out that we have been if we've got to pay it back.
Oh, I see. Yes.
So we no longer have the money because the money's been turned into coal
Well,
that we've given to farmers.
I think this is interesting, but it's not essential to your case because on any view,
And I'm not.
on any view, you come into the second category.
Yeah, and I'm obviously not
You're trying
making.
to win this case twice.
I'm obviously not making a sort of tracing point. I'm not making a property point. I'm just making a commercial reality. Why would the law apply a different test? Why would the law apply a different causation test to a situation where the money's been stolen or you've been defrauded into supplying coal on the basis?
Well, I'll tell you what. Let's see what Mr. Adam wants to say about. Adkin wants to say about this.
Yeah,
But I know you've got to get your retaliation in first. I know.
yeah, I'm happy to.
Okay. All right.
I'm happy to proceed on that basis.
Is there anything? I mean, that's a party, Mr. Adkin. We've got the point. But is there anything else you want to say on the first paragraph?
No.
Which, yeah, okay.
No. But then if we
yeah.
go to internal page 765,
Right.
and look under Roman 2.
We haven't looked at Delta Petroleum. Just
No, that's
flagged
the
that
next.
up.
that-
You've got Lord Leggett to come.
That's where we're going next.
Right.
But if I could just ask you, so internal number page 765,
Yeah.
you'll see the but-for test. So my lord, let's have a look at Delta because that's the authority cited by Professor Virgo. It's behind tab 24.
Well, it's not the authority for this proposition, is it?
Well, it's
The authority for the proposition on the previous page, isn't it?
yes, absolutely. Well, on the first page that we had a look at, which is the but-for test.
I notice there's another article which appears in a footnote supporting by a Bant the change of position defence appears supporting both of the passages you've referred us to.
I'm sorry, where's my lord looking?
Bant! There's an article by an academic called Bant, who seems to be a female academic. The change of position defence. That supports both propositions which you were looking at. The proposition on the last paragraph on 757 and
Bant.
on the,
Yeah, I'm afraid.
And then there's the footnote seems to add something. Anyway, do you want us to read 6765 or do you want us to go to Lord Leggett?
Well, my lord, it's just the first sentence of under Roman 2 in 765.
Right.
So the facts in Delta, that case concerned a contract between the BVI electricity provider, a statutory corporation, to buy oil from Delta. And the contract contained a term allowing Delta to suspend supply in certain circumstances. And the issue was whether the supplier had waived that clause. And first instance, court held that the clause had been waived, so the supplier was obliged to continue supplying fuel. The court makes an order for specific performance. Eventually, that order is overturned by the Privy Council. Delta then asserts a claim in restitution to recover the value of the benefit which it had been forced to supply by the order for specific performance, i.e. the difference between the value of the fuel and the price it had received. Now, the state corporation resisted that on the basis of change of position. It said it had passed on the benefit of the price differential to customers under the regulatory formula for electricity pricing. And it said that if it was forced now to make restitution of the benefit to the supplier, it wouldn't be able to pass that on to customers. The argument made by the supplier was that the buyer could only establish a defence of change of position if it could show it relied on the order for specific performance, and it couldn't say that it had relied on that order because it knew that it might be overturned. But the Privy Council held that the premise of that argument was wrong, because you don't need to demonstrate reliance on the receipt of the benefit. All you need to show is that the benefit caused the change of position. So you can have a change of position defence even if you don't know about the benefit. That's the wide view. And then, my lord, so we just need to look at paragraphs from page 768, paras 60 to 65. So if we could look at 60 just by the letter C. And just down to the letter D. So this is the judgment of Lord Legate.
Sorry, 60.
Sorry, my lady?
It was 60, was it?
60 at letter C. So just between C and D. And then once you've read that, if you could read paragraph 61. And then at 62, you see the board refusing to accept the premise. In the board's view, there's no reason why relevant changes in position should be restricted to those which have come about through decisions made and steps taken voluntarily in reliance on the receipt of a benefit. It's sufficient that the receiving the benefit has caused the change of position. And again, and then over the page, we look at the rest of paragraph 62. And then 63. So, my lord, I suppose the simple point I'm making is that the wide view has been preferred. That is in itself an endorsement of an expansive view of change of position rather than a narrow view of change of position. That's the first point. And the second point is that in relation to the wide view, where you're looking at the act of a third party intervening, then but-for causation is the only conceivable test that could apply. And it would be very different if any different test of causation were to apply where you're looking at change of position by reason of the voluntary act of the recipient. And just what basis could there be as a matter of legal policy for applying a different test of causation in those two separate cases? Because they're both focused on the question of whether or not it's inequitable for repayment to have to be made. So it has to be, but if it's but for in relation to one, then it's bound to be but for in relation to the other. My lord, the only other case that I wanted to take you to in this area was Haugesund, because my learned friend relied on it. It's at tab 15 of the authorities bundle. It's a very unusual case. You might remember the facts from my learned friend's presentation, but essentially two Norwegian local authorities borrow money from the defendant bank under contracts that are described as swaps but are essentially loans. And the designation of swaps was intended to get around the limitations on the powers of the local authorities to borrow money under Norwegian law. And the local authorities invest the proceeds of the loans or swaps and they suffer losses on their investments. The swaps contracts are ultra vires, so the bank can't recover the monies advanced under the contracts, but it's held that they're entitled to get it back in restitution. And in response to that, the authorities say, we've got a change of position defence. They say, they've used the proceeds of the swaps to make speculative investments and they made losses, and that's a change of their position. Now, the Court of Appeal just has no difficulty, as you expect, in recognising this argument as being horrifically unmeritorious as a matter of fact and as a matter of law, because the local authorities knew that the money had to be repaid. They never expected to be able to avoid repayment in the event that their investment decisions didn't pay off. They chose to make the investments hoping for gains, but bearing the risk of loss. And in relation to the change of position defence, they're essentially seeking a free ride, which was never the deal. They never thought they could use the money to make the investments and not have to repay. They never thought that they wouldn't have to repay if the investment decisions didn't work out. So really, this is just a case about whether you can have your cake and eat it. It's an unusual case because it's a case where a contract of loan is being void and the resulting claim is in restitution. Can you say in those circumstances, I've used the money, so I shouldn't have to repay what I always knew and anticipated was a loan? It really doesn't get you anywhere for the purpose of this case. I could just show you at page 425. If you look at paragraph 122, and the observation at secondly is particularly important. And then thirdly, so on the wide view, all of these questions are aimed at looking at whether it's unjust to allow the claimant to have restitution in whole or in part. That's the ultimate question, and that depends on whether the defendant has so changed his position that the injustice of requiring repayment outweighs the injustice of denying restitution in whole or in part. Then in paragraph 1, 2, 3, you see the reference to a distinction between those cases where you always know that the money is going to have to be repaid, and those circumstances where you're receiving the money to use for your own purposes. That's at 1, 2, 3. And of course, if you know that the money's got to be repaid, then it's no, you haven't changed your position in any relevant sense. If you've just taken the money and used it for your own, for your own
You
purpose.
don't challenge any. You don't suggest that Lord Justice Aiken's analysis or summary is anyway contrary to the.
Absolutely not.
It's no.
It's just a completely different sort of set of facts to our case. No, it's bang on the money. I mean, in my respect, it's a very straightforward result from, I don't know if it's disrespectful to say this, but a very obvious case. We see that from 1, 2, 4. The local authorities knew when they took the money that they were going to have to repay it. So, well, that's really all I wanted to say on the law, and I've just got some relatively brief submissions to make on the grounds that are maintained in this appeal. Starting with ground 2, the question of causation. Now that we understand what the principles are and that you're seeking to establish whether there are circumstances that make it inequitable for money to have to be repaid, we've seen that in paragraph 122 from Lord Justice Aikens in Haugesson. That's the relevance of the question of change of position. And for the purpose of the causation, it's really important to orientate ourselves so that we understand what we're looking at, what assumptions we've got to make if we're starting off with causation. So, for the purpose of the causation argument, one has to proceed on the basis that we didn't suspect that there was any mistake. So we're just isolating causation, but we operate on the basis that we didn't suspect any mistake. We start on the basis that if the payment hadn't been made, we wouldn't have delivered more coal and we delivered that coal on well, either on credit or on the basis of having received these monies that it's now suggested we have to repay. The question being, having delivered the coal on the basis of our understanding, should we now be forced to repay to Rasmala the price of that coal? And that commercially, that's what's being asked. You've delivered $22 million worth of coal, but you've got to give up the $22 million. So effectively, you've given $22 million worth of coal to Farlin, and you get nothing back from it. That's why I say the analogy with theft is a close one. And Rasmala's argument, as you know, is that when Trafigura changed its position, it did so in reliance on the TPAs. As for their point on allocations, we've discussed it can only apply to payment 1. You know the basis on which we don't accept that. We say we still acted in good faith, but and you've got our point in relation to the subsequent payments. In relation to the subsequent payments, it's simply impossible to understand, we suggest, what there is that breaks the chain of causation between the receipt of the payments, our belief in their validity, and the conduct that constitutes a detriment. My Lord, we have identified in our skeleton at paragraph 37 well, we can start at paragraph 36. We've identified what we say are some of the absurdities that would result from Rasmala's case being accepted. So our skeletons at tab 3 of the core bundle, looking at page 43. Really, it's very easy to imagine further examples of absurdity. And we just give some of them at paragraph 37 over the page at paragraph 44. And really, I suppose in large part, this picks up on an observation that my lady made yesterday when discussing the matter with my learned friend, that there's always got to be something in addition to the payment that indicates to the recipient that he or she is entitled to use the money for the purposes that constitute the detriment. It can't just be the payment itself. And I think my learned friend was minded to accept that. And he said, well, you know, if you receive a payment without any indication of what it's being used for, then obviously you've got to make inquiries. My lady's observation with respect is one that we'd adopt. There's always going to be something in addition to the fact of the payment. And we've just raised some questions in paragraph 37 that we respectfully say haven't been satisfactorily addressed. Perhaps number 2 is the most, is the most apposite. Again, the understanding of the recipient has to be judged at the date of change of position, not at the date of receipt, because otherwise you get a situation where you receive the payment. After receipt of the payment, you discover that it's been made by mistake. Well, then obviously your change of position after you have that information can't be made in good faith. But we say the obverse of that is obviously must follow. If between the date of the receipt and the date of the change of position you get information that shows you that the payment is valid and that you're entitled to change your position in the way that you do, then you're okay. So if that's not right, then you've got real problems with the other side of the coin. And another good example, just on the facts of this case, relate to payment 5, which I'm going to come on to. Because as a matter of causation, we seem to be in a significantly better position in relation to payment 5 because we don't get a TPA. And with respect, that just makes absolutely no sense at all. You can't, but again, that's what my learned friend's case is. We're worse off because we demanded TPAs and because we got TPAs and we thought that they were effective. My lord, then risk-taking, ground 3. You'll have seen how the judge dealt with that at paragraph 101, but the suggestion is that as a matter of risk allocation, the risk needs to be allocated to Trafigura. But we say with respect, that's just completely question begging. We just ask rhetorically, well, why is Trafigura the risk taker in this scenario? Risk allocation, we say, isn't a separate part of the legal test. Sometimes a judge will stand back and consider who should bear the risk, but it's not a separate part of the legal test. And you certainly want to avoid the concept of relative fault coming in by the back door, which is where this kind of analysis is most likely to lead. And in fact, if you look at if you consider my learned friend's submissions on allocation of risk, they're really a great similarity to what you'd say if the test were one of reasonable or of relative fault. But I've taken you to the cases, Rose and Webber, that concern or that raise questions of risk taking. But they're both cases where the risk has been consciously taken. I mean, otherwise, the concept of taking risk actually does no work, does no analytical work. Either it involves going back to a negligence test or to a relative fault test. But obviously you can see where you're knowingly taking the risk, then the situation might be a little bit different. So you can use the term risk taker as shorthand to describe a party who suspects that the payment is mistaken, but let sleeping dogs lie. So it's not a separate context. The only other case relied on by Rasmala in terms of risk taking is the Haugesson case, which we've just looked at. But that's risk taking in a completely different sense. The risk there was that the investments wouldn't pay off. So in Rose and in Webber, the recipient was aware that they might have to repay the money, and they took the risk that they would have to do that. In Haugesson, the local authorities knew that they were going to have to repay the money. It was a loan, so they weren't taking a risk they might have to repay the money. It was a known fact. The risk they took was that the investments wouldn't pay off. So Trafigura isn't a risk taker in any relevant sense. And as you know, unlike Mr. Webber and AIB Bank, Trafigura did make further inquiries after the payments had been made. They acted on legal advice, and they didn't subjectively understand there was a risk, and that's a finding that the judge has made. Ground 4, the wrong test for acting in good faith. My lord, I've got nothing further to say on that. That is an unsustainable argument.
Okay.
Sorry, Mark?
Okay, yes, so ground 5.
And then ground 5, which is, I mean, we say, with respect, the most difficult of all the points, really, because this relates to payment 5. It
Yes.
essentially treats our internal processes in relation to TPAs as legal requirements, which they're not. I won't go back to my theology, but you see that what the judge says at paragraph 99, that they're not general practice, they're good practice. The purpose of the TPAs was actually to protect Trafigura, and that's, I won't take you to it, but Mr. Gukali, paragraph 37, supplemental bundle tab 3, page 62, as you'd expect. The purpose of it is to make sure that Trafigura is protected. So for the argument to work on payment 5, again, I've said that it's sometimes useful to say, well, what do we need to assume in order to follow through the consequences of an argument? Well, for the purpose of this argument, we have to assume that payments 1 to 4 are fine. Otherwise, ground 7 is irrelevant. Ground 7 is only relevant if payments 1 to 4 are absolutely fine, but for some reason, Trafigura is not acting in good faith in relation to payment 5. And we just say, that's not what the judge found. And any suggestion that he should have found that is just a wildly unlikely suggestion. Fraud or mistake is just the last thing that we would have considered at that point. We would have had to think that the previous TPAs were forged, but you know we didn't think that. And we'd have to think that for some reason Farlin had decided not to provide a forged TPA for payment 5. So really all my learned friend is left with is the fact that Trafigura anticipated that a TPA would be signed off so that our internal processes could be complied with. My lord, that doesn't mean that Trafigura thought there was any issue with the validity of the payment. It's just impossible to say that the anticipation of a TPA breaks the chain of causation. And it's important for the court to remember the way in which this aspect of the claim was pursued. Rasmala's case was that the three individuals either knew or suspected that the TPAs weren't genuinely agreed to by Rasmala. At least in either knew or suspected. Again, don't need to take you to it, but the original case, you will see in paragraph 40 of the particulars of claim, core bundle tab 10, page 40. Shortly before trial, Rasmala served a draft amended pleading to say it maintained its case, at least in relation to Mr. Jasani, that the terms of the TPAs were so unusual that Mr. Jasani couldn't have genuinely believed that Rasmala had agreed with him. So the pleaded case which Rasmala advanced at trial remained that the TPAs were badges of fraud. So the existence of the TPAs themselves was indicative of a lack of good faith. And indeed, the attempt was made to appeal the judge's finding that the TPAs were not badges of fraud, but that attempt was refused by Lord Justice Miles. But given that remained Rasmala's pleaded case, it is a little bit surprising that it argues the exact opposite in relation to payment 5, that the absence of a TPA is indicative of bad faith or relevant to causation. But my lord, it was certainly never pleaded as being any such thing. And we note, as my learned friend accepts, that payment 5 was in part covered by TPAs 3 and 4. So it's accepted that we knew or thought that Rasmala was happy for payments or part of payment 5 to be allocated to that historic contract. So on what basis we suggest can it be argued that we suspected that the remainder of the payment was made pursuant to a mistake? The suggestion has to be, and let's just step back and just consider what you're being asked to find. You're being asked to find that we suspected that part of the payment was not made under a mistake, i.e. the part that's covered by TPAs 3 and 4, but the remainder was paid under a mistake. Well, that's just not sustainable. It's inconsistent with what the judge found. The only conceivable mistake could be as to allocation, but as to that, you have the judge's finding on paragraph 43 that we didn't have any suspicions in relation to allocation. As a matter of law, actually, in circumstances where a payer doesn't allocate, the recipient can. So actually, as a matter of law, we were entitled to allocate it how we wanted on the assumption that Rasmala were paying on behalf of Farlin. I won't take you to it, but that's the Thomas against Thomas case, tab 19, tab 13. Page 351. So ultimately, my lord, we rely on the findings made by the judge. I've referred to 43. You've seen 55 to 56. You've seen that the judge found that there were no red flags. You've seen the last sentence of 110, which says the later payments, as you'd expect, reinforce Trafigura's belief that everything is fine and on the level. You've seen the explanation at paragraph 102 that historic allocation is just not important or not thought to be important or significant. And you've seen paragraphs 112, 113, a finding that Trafigura had no reason to suspect and did not suspect that any of the payments were repayable. So we say this is impossible by reason of the findings made, and in any event is just unreal on the basis of facts. To say the idea that we suspected that payment 5 or part of payment 5 was made by a mistake is simply unarguable. I mean, as you know, as the judge explained, after payment 5, we continue to make further deliveries of coal,
Yes.
which is another very good indication that we didn't think that there was any problem with it and that it would have to be repayable. So as I say, we carried on making payments of coal in relation to it. And the judge expressly found at paragraph 102 that the continued trading was caused by the receipt of payment 5. And that finding is not challenged on appeal. So just to remind you of 102, it follows the absence of a TPA for payment 5 doesn't prevent Trafigura having a change of position defence. The change of position is its continued trading with Farland because of the payment.
Yes.
So, my lord, unless there was anything further I can help you with in relation to the existing grounds, those are my submissions.
No, thank you very much, Mr. Kitchener.
And now,
Mr. Naden.
I'm grateful, my lord.
Yes.
My lord, my lady, in relation to the new ground, is that okay? Can you hear me now? I'm proposing to adopt the same structure that my learned friend did. So I'm going to address the merits of the grounds first, and then I'll deal very briefly with the question of permission at the end. So as to the merits of the ground, I'm going to start with a few propositions of law, if I may. The first one is that the overall principle, as we've seen repeatedly, is that the recipient will have a defence where his position has so changed that it will be inequitable in all the circumstances to require him to make restitution. That's Lipkin Gorman at 580,
Yes.
which we've seen, which is quoted by the judge in his judgment at paragraph 93. My learned friend, Mr. Kitchener, showed you a similarly broad statement from Halverson at 122.
Yes, Lord Justice Aikens.
Indeed.
Yes.
So it's a broad principle, and it's a deliberately broad principle, as Lord Gough explained in Lipkin Gorman.
Yeah.
Secondly, the relevant detriment does not need to be financial or even capable of being measured in pecuniary terms. The authority for that is the Commerzbank or Commerzbank
Yes.
that we looked at and you heard reference to. And that's referred to by the judge in his paragraph 93. Sorry, in his paragraph 103.
Yes.
And my learned friend expressly confirmed yesterday that that's not disputed. So that's proposition 2. The third proposition is that a lost opportunity can constitute a relevant detriment, even if it's not quantifiable, as long as it's substantial and irreversible. And again, that's a point the judge made in his paragraph 103 in the judgment. And again, that was helpfully confirmed by my learned friend yesterday that that's not disputed either. Now, in his paragraph 103, the judge refers to a case called Australian Financial Services for that proposition. And I'd like to take you to that case, please.
Yes.
Because it chimes with the facts of our case. We've seen lots of cases where the facts are materially different to our case. This is one where the facts are helpfully similar. It's a decision of the High Court.
Where is it in the bundles?
It's tab 19, my lord.
Thank you.
Which starts on page 610. It's a decision of the High Court of Australia,
Yes.
and it's a case in which the detriment consisted of giving up an opportunity to recover debts. And the court held that such an opportunity can constitute a relevant detriment, even if it's not possible to quantify how much would have been recovered through those debt recovery efforts. And as I say, the facts of this case bear a resemblance to our case. They're in the judgment at paragraph 39, but I'll try and summarise them if I can. 39 and 40 in the judgment, which starts on page 622 in the bundle. There were two companies. They were called Hills and Bosch, and they were companies that manufactured and supplied commercial equipment. There was a third company called TCP, and that company owed substantial sums to both Hills and Bosch. It owed Hills about $300,000 and it owed Bosch $200,000. The director of TCP tricked a financier called Australian Financial Services into making payments to Hills and Bosch using forged documents. Sounds familiar. In this case, the financier thought it was buying equipment from the suppliers, which it would then lease back to Hills and Bosch. But in fact, the equipment didn't exist. So Australian Financial Services is duped into making payments to Hills and Bosch, and the size of those payments are sufficient to pay off the entirety of the indebtedness of those companies. Hills and Bosch receive the payment from AFS, apply the monies to satisfy the debts, they so think, and treat those debts as having been repaid. And in reliance on having received that money and allocated the money to the historic debts, they stopped taking steps to recover those debts. By this stage, Bosch had already acquired a default judgment against TCP. Because it had received the money from the financier through this fraud, it agreed to set that default judgment aside, and it discontinued the proceedings against TCP. Hill was about to start commencement proceedings, but because it had received this money from the financier, it didn't do so. And it began starting trading with TCP again. And it started supplying equipment on credit to TCP. Again, sounds familiar. What then happened was TCP went into insolvency. And when it did so, it owed Hills, one of the two suppliers, $20,000. I'll come back to that number in a minute. The financier then discovered the fraud and sought to recover the monies from the suppliers, Hills and Bosch. They said, well, they resisted that claim on the basis of change of position. They said, because you paid us the money, we lost the opportunity to recover the debts that were owed to us by TCP. We were taking proceedings to recover those debts, and if we continued to do so, we might have been able to recover money from them. It was in a position potentially to pay us. But as a result of the payments we received, we stopped taking those proceedings, released the default judgment, etc. And now, because TCP is insolvent, we can't get anything. So they said, we're in a worse position than we would have been if you paid us the money. In the High Court of Australia, Claimant, AFS, argued that in order to establish a defence of change of position, the detriment needs to be a quantifiable disenrichment. So the defendant must show it's worse off in a quantifiable way. And the argument was, because Hills and Bosch can't prove what would have happened in the counterfactual world, where they took steps to recover these debts, they can't say how much they would have got back from TCP in that counterfactual world. They don't have a defence. Or alternatively, they wouldn't have got anything back from TCP because it was in such a parlous state, those issues would not have been successful, even if they'd been pursued. I don't propose to turn it up, but we can see that that was the argument at paragraph 36 and 61 to 63 in the judgment. So in this case, AFS was essentially making exactly the argument that Rasmala ran at trial. And it's fairly similar to the argument that's now advanced us on this appeal. The High Court of Australia rejected that argument, and it went on to hold that, even though it was not possible to quantify the detriment that Hills and Bosch had suffered through losing this opportunity to stop the clock and recover the debts, they had a defence of change of position. And they had a defence that was a defence to the whole claim, not just part of it. Now, the court was unanimous in that decision, but there are three separate judgments.
Yes.
So it's somewhat unwieldy to navigate. So I'm going to show you, hopefully, the relevant passages from the three judgments, if I may.
Yes.
If we can go first to the first judgment, which is the judgment of Chief Justice French, and look at paragraph 4, which is on page 612, please. And it said the appeal should be dismissed. The respondent suffered an irreversible detriment when they decided, on the faith of the receipt of the payments made to them by the appellant, not to pursue their legal remedies against the fraudulent client from TCP. Change of position may apply as a pro tanto defence where the detriment can readily be quantified. This is not such a case. Contrary to the submissions of the appellant, change of position applies in this case as a complete defence to the appellant's claim. Then if we could go on to paragraph 22, please, which is on page 618.
This is still the Chief
This is
Justice.
still the Chief Justice, yes, my lord. You'll see there is a citation from Dextra, where we see another description of the principle of change of position in broad terms, as in Gorman. And then the learned Chief Justice says, the citation from Dexter and Robert Walker in Scottish Equitable militates against the confinement of the defence to a quantitative disenrichment analysis. It shouldn't be a strictly mathematical exercise of debits and credits. If we then go over the page, please, to page 619 in the document. You see at the bottom of the page, the start of that unnumbered paragraph, the Chief Justice says he's applying a criterion of irreversible detriment. He thinks that's the appropriate test.
So which page are you on?
I'm on page 619.
Yes.
It's paragraph 25, but it's the third paragraph within 25.
After the quote.
Exactly. So he's applying a criterion of irreversible detriment rather than a quantitative analysis.
Where does he get the irreversible detriment from?
I think he gets that from Miss Bant, who my lord referred to earlier.
Oh,
Professor-
yes, Professor Bant.
Indeed. She crops up here too, at the bottom of 618, top of 619. It's a concept from her book, I believe. And then the next paragraph I'll just draw your attention to is paragraph 26, where the Chief Justice describes the appellant's central proposition as being that the defence only operates to the extent of the value of the enrichment, which the court must determine as best it can, i.e. you have to have a disenrichment that is quantitatively assessed, and he says that proposition is too general and should not be accepted. And then on the same page, could I please invite you to read paragraphs 29 and going over the page to 31, please?
Okay.
I'm grateful. So the conclusion is that defendants or respondents have suffered an irreversible detriment by losing the opportunity. And I ask you to note caution against the difficulties of assessing counterfactuals
Yes.
at trial, and the difficulties one has in exploring what would have happened and what would have been the quantitative results of those various counterfactuals. That chimes with another case I'm going to show you shortly. So that was the judgment of the Chief Justice. We then have the judgment of 5 justices.
Hayne and others.
Exactly. And that starts at paragraph 32, but I'd like to jump ahead, please, to paragraph 84, on page 630. It's just the first line, or first 2 lines of paragraph 84 I want to draw your attention to. Under Australian law, a mathematical assessment of enduring economic benefit does not determine the availability of restitutionary remedies. And we will observe that that's the same here too. It's not a purely mathematical exercise, it's a much broader evaluation.
Mm-hmm.
And then, please, if you can jump ahead to paragraph 95, which starts on page 632. And if I could please invite you to read paragraph 95 from, I think it's 6 lines down. You see a sentence that starts even. If I can ask you to read from even down the page and then paragraph 96 on the next page, please.
Yes.
Thank you. So that's the judgment of the plurality, as it were. There's then a third judgment from Mr. Justice Gagler.
And this is the one which is cited at various other places, isn't it?
Indeed.
Yes.
He's now the Chief Justice of Australia. He stops on paragraph 104. So again, I'd like to jump ahead, please, to paragraph 157, which starts on page 647 of the bundle. And in particular, in paragraph 157, I'd ask you to read, I think it's about 8 or 9 lines down, there's a sentence that starts with the second condition. He says, the second condition is that by reason of having so acted or refrained from acting, the defendant will be placed in a worse position if ordered to make restitution of the payment than if the defendant had not received the payment at all. The detriment constituted by that difference in position need not in every case be financial or pecuniary, as you see. If financial or pecuniary, it need not in every case be established with precision. It can be an opportunity forgone. It must in every case be shown by the defendant to be substantial. We say that's an accurate statement of the law of England too. And then if we go across to the next page, 648, paragraph 161, Mr. Justice Gagler identifies the 4 sources of detriment that Hills said it had suffered. You can see 4 there. And then he goes on to examine them separately. Firstly, he discusses whether or not the debts had been discharged. We need to get into that. But can we jump down, please, to paragraph 165? And if I can ask you, please, to read to yourselves 165 and 166.
Thank you.
I'm grateful. These passages are important because in 165, the judge identifies that the only quantifiable detriment that Hills had suffered was the fact that at the end of the story, it was owed $21,000. At the start of the story, it had been owed $308,000 by TCP. It had then received that amount of money from the financier AFS, so that debt was completely discharged, or treated as being completely discharged. But then it racked up a further debt of $21,000 to TCP because it started supplying money on credit. Supplying equipment on credit, I should say. So at the start it's owed $308,000. At the end, after the payments are made, it's owed $21,000. So on my learned friend's argument, it ought to have had been required to repay the difference between the 308 and the 21. So my learned friend's argument is, unless you are required to pay the difference between those sums, the benefit that you've received, the payment, and the detriment you've suffered, the 21, you would be better off than you were at the start.
Yeah.
So they should have been, on my learned friend's logic, been ordered to repay the difference, 290,000 odd. But they weren't. The High Court of Australia rejected that argument and held that Hills had a defence to the entire claim. And that's because of what we see in 166. They had lost the opportunity to stop the trading before the payments were made. and call in or seek to recover all of the debts that were owed to them by TCP at that point in time. They lost that opportunity. They can't quantify that opportunity because they can't say precisely how much they'd have got from TCP if they'd taken those steps. But the fact that they can't quantify it doesn't prevent them having a defence. Actually, they have a defence to the entire claim, not just everything apart from the 21. So we say there's a pleasing similarity in the facts of this case, because the detriment that's relied on is the same, as in the opportunity to repay stock time and repay debts. That is the opportunity that's lost as a result of the payments. But our case is much, much stronger than this, because at the end of the story in our case, when the music stops, the debt that we're owed by Farlin is bigger than it was at the start.
Yeah.
Because before the payments it's 12 to 14 million, at the end it's 15 million. So our facts are much, much stronger than this case, in which respondents were held to have a total defence.
Thank you.
So that's the Australian case. I should say that this case and that principle about opportunities to call in debts that are unquantifiable being sufficient to constitute a detriment for these purposes, that's been followed by in a decision by Mr. Justice Foxton, as he then was, in the Bankett and Tessa case.
Do you have that?
I do have copies of that, and if you'd like to look at it, I can hand those up. That would be helpful.
Well, I think we would like to see it when we retire. Whether you want to refer to it now, have you?
I can take you through it very quickly now.
Have you told Mr. Mohammed Bai that you've seen it? Yes, he nods that you have. I'm sure you had.
Unfortunately, a lot of trees have died in the consequence of printing this case out. It is enormous. So, thank you. The relevant passage starts on paragraph 415, which is page 517, where the learned judge is considering some issues of law in relation to the defence of change of position. And he's identified several questions which arose in that case. One of which was, as we see at 416, the defence of change of position is limited to cases in which a reduction in the recipient's assets in a particular amount can be established, or whether it can apply when something inherently more uncertain in quantitative terms is made out. And he refers to the judgment of Scottish Equitable, which we've looked at several times.
And then at 418 he refers to the Australian case.
Exactly. And if I could ask you to read, please, 418 and 419. We'll see Professor Bant appears again in this judgment.
Yeah.
So the decision in Australian Financial Services is approved and followed in this case. I should say that there was an appeal from this decision of Mr. Justice Foxton, I know you know, and he was overturned on some issues, but there was no criticism of his analysis or his adoption of the Australian case that we see here.
I don't think this.
It didn't arise.
Thank you.
And the final legal principle is that when considering whether a defendant has suffered a detriment, the court should take a generous approach to the level of proof that is required to establish that detriment. And that's because a recipient of a mistaken payment who changes their position in good faith will by definition have thought they were entitled to the money. That's what a good faith change of position is. So they are unlikely to have anticipated that in the future they may need to prove precisely how it is they changed their position. So they're unlikely, for example, to have created detailed records about how they improved their lifestyle, for example. And this chimes with what my learned friend Mr. Kitchener was saying earlier about one has to view the defensive change of position in the context of, well, the defendant is someone who's, in this case, received a mistaken payment. A mistake has been made and they've received the money. And that has implications for how strict the but-for test is, why the relevant test about the mental capacity of the mental state of the defendant is good faith rather than negligence, and in this case, why the court should take a generous approach to proof of the detriment. And let me show you an authority that makes that clear. It's Scottish Equitable again, and it's tab 6 in the authority.
Well, generous approach is inherent in the case of just being shown, which will moment of time actually says.
Do you want
this
to
is
just give us a reference
I
to
shall
what
do.
Lord Justice Walker?
It's mercifully very short. It's paragraph 33,
Okay.
page 201.
Unless you want us to look at it, we'll just write a note, I think.
Let me at least read it into the transcript because it is brief. The judge says, I would also accept that it may be right for the court not to apply too demanding a standing of proof
Yes.
when an honest defendant says that he has spent an overpayment by improving his lifestyle but cannot produce any detailed account.
Sorry, paragraph.
That's paragraph 33, it's
Thank you.
like 2/3 of the way down.
Well, I can understand why you wanted to read it in. It was commendably succinct. Yes.
So that's the law. Can I now turn to the evidence and the judgment? The position I think is, and I think we all understand, is that immediately prior to the first payment in August 2017, Farlin owed Trafigura between 10 and 11 million for physical cargo, and somewhere between 1.7 to 3 million in demurrage. So there was a total exposure between approximately 12 to 14 $1 million. And we can see that in the judgment of paragraph 104.
Yeah.
And the judge made findings of fact to that effect, and those findings are not challenged. So at the start of the story, that is 12 to 14 million. As you know, what then happened was Rasmala made a series of payments to Trafigura of about $22 million, and Trafigura used those payments, or allocated those payments, to satisfy Farling's existing debt under its rolling credit facility. From Trafigura's perspective, that freed up Farling's credit facility, so that further coal could be and was supplied by Trafigura on credit. And indeed, Trafigura did supply more coal. Again, it's probably helpful if we go to the judgment, see what findings the judge made on this. You'll be familiar with most of these, I think. We start in paragraph 98, please.
Yes.
The judge says Trafigura says that the payments caused Trafigura to continue to trade and supply more coal. Trafigura's witnesses, such as Mr. Nuru, were clear, and I accept that if the payments had not been made, further deliveries to Farling would not have been made. They had exceeded the credit of Trafigura. And he gives a specific example of that happening, which is in the evidence. And then he says, because the payments were received, a further 15 new contracts were entered into by Trafigura for the supply of coal to Farling between the 22nd of September 2017 and the 8th of May 2018, with an invoice value of just under 60 million.
That suggests there must have been, it's not just 22 million worth.
I don't want to give evidence
Yes,
particularly
but
about
there must be a lot more.
there was money from elsewhere.
Yes, there
from
must
Falling
be.
from other sources. I think that must be right. If we then go to paragraph 101, please. And I'm looking at the last 4 lines. And we've seen this already. The payment, however it was applied, had the effect of reducing Falling's overall liability below the credit limit and so permitted future trading. In such circumstances, I don't consider it inequitable for Trafigura on its continued trading with Falling as a change of position. And then please over to a paragraph 105. Firstly, the judge referred to some evidence about the small level of profit on the 15 contract. And then he says this at the end, which is important. In substance, apart from that small profit margin, the monies received by Trafigura in respect of Falling's contracts were being used to meet the costs of supplying coal to Falling. This is the point which he was making a moment ago. And then in 106 to finish off, the judge says it's obvious we will be financially worse off if we fail to repay the payments in full. It has continued to trade with Falling since payment 1 and continued to supply coal. So that's what happened. The money freed up credit. As a result, more coal was supplied on credit.
You also want the figures in 104, don't you? When Trafigura eventually stopped trading, it was approximately 12 million.
Exactly, that's where I'm going right now.
Right.
So, as you say, Falling eventually stops trading in 2018. At that point, as my lord just pointed out, in paragraph 104, the judge finds that at that point, Falling owed Trafigura about $12 million for physical coal, plus $3 million in demurrage and interest. So a total debt of around $15 million at that time, as compared to a total debt of between $12 to $14 million in August 2017. So the debt owed by Falling to Trafigura at the end was higher than it had been before the payments had been made. And to be clear, that was the case even though Rasmala had paid Trafigura $22 million, and Trafigura had allocated and treated that money as having satisfied Falling's debts or treated them in that way. So even with the $22 million from Rasmala, Trafigura was in a worse position, and that is precisely because, as Mr. earlier, it had supplied $22 million of coal and more to Falling. Just pausing there, we say it's obvious, just comparing those two numbers, that Trafigura has suffered a detriment by continuing to trade. The debt was bigger at the end of the story than it was before the payments were made. And further, and this is really the key for that change of position defence, if Trafigura were now required to pay back the 22 million, or part of it, it would suffer an even greater detriment. It would be the debt, as it were, or the downside would have got even bigger. And we say that's obviously a significant detriment. And that is the point that the judge made at paragraph 106, where he says, looking at the figures, it's obvious that Trafigura would be financially worse off if it were required to repay the payments. And we say he was absolutely right about that. Now, my learned friend's argument is, well, actually, that's not the end of the story. It's in 2018 and onwards, Trafigura was able to recover some of the $15 million it was owed. And the evidence on that was Trafigura was able to recover approximately $3 million from Falling, and it was able to recover approximately $4.5 million under its credit risk insurance. So when you take all of those together, Falling's loss ultimately was between $7 and $7.5 million. And again, that's what the judge found in paragraph 104. And my learned friend's argument is, well, 7 to 7.5, that's the loss you suffered at the end. That's a lower number than the 12 to $14 million you were owed before the payments were made. So you're obviously in a better position as a result of the payments. Depending on which figures you choose, you're better off between 4.5 and $7 million. And he says, well, that you ought to be required to pay that money back So otherwise, you will be better off. But the short answer to this is that obviously doesn't compare like with like. To use the words that Mr. Nugee used in evidence, and as we saw yesterday,
Not apples and apples.
it's not apples and apples. My learned friend wants to do is when calculating the loss Trafigura ultimately suffered, is to take the benefit of the recoveries that were made from Falling, to take the benefit of the recoveries under the insurance. But when you're looking at what the position was before the payments were made, they want to ignore all that and ignore the possibility of claims from Falling. And I'll show you that the certainty of a claim under the insurance, they want to completely ignore that. And that is not comparing apples with apples. The assumption seems to be that if the payments hadn't been made in August 2017, the Trafigura wouldn't have recovered anything from Falling or anything under the insurance. And there's just no basis for that in the evidence. And we say it's just completely unreal as a matter of commercial reality. The evidence was, and I'll show you shortly, that if Rasmala had not made payment 1, Trafigura would have stopped trading with Falling and would have taken steps to recover its outstanding debts.
From Falling and insurance credit.
Indeed. So first it would have gone to
Credit
Falling,
insurance.
and if the evidence was if those efforts had been unsuccessful, it would have claimed under its credit insurance.
The same steps to mitigate its loss.
Indeed, as you would have imagined it would. And let me show you that evidence again, because my learned friend showed you it yesterday, but I'd like to revisit it to point out the key parts, if I may.
Yes.
So the first aspect of this is Mr. Maru's witness statement.
Just a moment.
Sorry, excuse me.
Yes, do carry on. And we did have seen this earlier, but take whatever course you want.
I think
Mr.
there's
David.
one passage that perhaps you didn't see yesterday. I should show you in Mr. Maru's statement. So this is Supplemental Bundle Tab 2,
Yeah.
page 45. And it's in paragraph 45. It's about 6 lines down. There's a passage that starts after. I don't recall you showing this yesterday. So if you could just read that, please, from after.
Which paragraph?
Paragraph 45.
On 45.
Yes, paragraph 45 on 45. Hopefully.
Yep.
And it's 2/3 of the way down. There's a section that starts after.
Mm-hmm.
And then there's paragraph 48, which you were taken to yesterday by my learned friend. And you may recall it, but if about 7 lines down there's a sentence that starts my understanding. If I could ask you to read that paragraph and just remind yourself of what Mr. Nugee says. The rest of that paragraph, please.
Yes.
So Mr. Nugee makes the point that if the payments had not been made, Trafigura would have stopped trading and tried to recover those debts. That aspect of the evidence is not challenged at all in the determination. Yesterday in his submission, my learned friend focused on the last sentence. And his submission was, I quote, that Trafigura would have tried to avoid claiming under the insurance. In my respectful submission, that's not a fair interpretation of that evidence. I think it's obvious that Trafigura would have preferred to get all of the money back from Fallen if it could, as anyone would prefer to do, rather than claiming under their insurance. But there is no basis in this evidence at all to suggest that Trafigura would not claim under that insurance if it had to do
Or
so.
that their approach would have been any different at that stage than it was ultimately.
Indeed.
They may well have been reluctant to claim on their insurance, and that reluctance was the same at any point.
Exactly. The proof is in the pudding as to what ultimately happened, in that they did claim in 2018. And indeed, Mr. Maru made clear that they would have claimed in 2017. Can I just show you that very quickly before the short adjournment? That's in the transcript.
Yes.
Day 3, so that's tab 6. It's page 154 in the bundle pages, please. And the passage, the relevant exchange starts in internal page 75. Again, my learned friend did show you this yesterday. And this is an exchange between Mr. Power, who is counsel for Rasmala, and Mr. Maru. And Mr. Power, rather, was trying to put to Mr. Maru the argument my learned friend makes now, i.e., you were owed 12 to 14 million at the start.
Yes.
You were owed 7 million at the end. 7 is less than 12. You must be better off. And Mr. Maru does not accept that. And we can see the argument being put to Mr. Maru in page 75. And then Mr. Maru's key response is in the middle of page 76, where he responds to the theory that's been put to him. So even at that moment, i.e. 2017, if hypothetically Trafigura had decided not to continue with business with Falk, we would have, and Falk had not paid, we would have still made a claim under the insurance, and the insurance recovery would have been 50%. So he's very clear, we would have, and we would have got 50% back. And then Mr. Power, I think, misunderstood what he was saying, because he said that you can't claim twice, the judgment intervenes. And then at page 77 of the transcript, Mr. Power has another go. Again, tries to put the same theory to Mr. Maru, and it doesn't go any better the second time. Mr. Maru comes back.
It's a bit cruel, Mr. Nate, but we got the point. We've seen this already, haven't we?
Indeed, and Mr. Maru says you have to compare. But it's important, I think, in page 78 of the transcript, where you look at Mr. Maru's numbers. He's assuming that the outstanding debt is 9 million to 11 million. He says that takes Trafigura to 4.5 million to 5.5 million on the recovery front. So he's obviously talking about the claim under the insurance, or on the loss front, 4.5 to 5.5. And then he adds on the demurrage. So again, he's making the point there in page 78 of the transcript that Trafigura would have claimed in 2017.
Yes.
And it's important that that's not challenged. Mr. Power doesn't say, well, you would have claimed under the insurance, Mr. Maru, would you? Look at what you say in your paragraph 48, which my learned friend now relies on. There's no challenge to the evidence that they would have claimed in August 2017.
Is his maths right?
The maths is
Mr. Maru's maths.
Mr. Maru's maths. He's working on the figures that he was being given by Mr. Power.
So they're not quite right on the judge's figures.
They don't quite match the figures we're using now.
Does that matter?
It doesn't matter for my purposes. The point I'm making is, in his analysis of the figures, he's starting with the headline loss that Mr. Power gives him, which is 9 million to 11 million.
The point is, it's 50% recovery.
Exactly.
Exactly.
He starts off with a slightly different number to that which we now use, but the point is the same.
Right. Well, yes, but even if you use the figures which we now have, 10 to 11 million for physical cargo, you would have recovered if you'd claimed on the insurance between 5 and 5.5 million. And then if you add 1.7 to 3, you've still got a range of 6.7 to 8.5.
But you have a range.
And that's leaving out of account any recovery from Falk. And it is striking that when the trading finally stops, you can still manage to extract 3 million from Falk a year and a half later.
Indeed.
Right. How are you doing, Mr. Naden?
Nearly done, I would say.
How nearly is nearly.
10 minutes max, I would say.
Well, we'll resume. We'll rise now and resume at 2 o'clock. Thank you very much.
Rises